You ever wonder why some apartment buildings feel like they have 100 bosses, but somehow nobody is actually in charge? That is basically what happens when multiple landlords or property managers split up duties on the same building, and then something breaks and someone gets hurt. Picture a staircase with a busted railing in a building owned by one company but managed day to day by another company, with a maintenance contractor hired by a third company. When you slip and fall, your brain is not thinking about corporate structure, it is thinking, ouch, but your case absolutely depends on untangling that structure. Lawyers start by asking one simple question: who had the duty to fix this thing? Duty just means whose job was it, kind of like figuring out which sibling was supposed to take out the trash before everyone starts pointing fingers. Lease agreements and management contracts are the real treasure map here. Buried in those boring pages are clauses that say exactly who handles repairs, who handles safety inspections, and who handles complaints, so lawyers read them like detectives looking for fingerprints. Sometimes the property owner hires a management company and basically disappears, never checking on the place at all. That does not mean the owner is off the hook, because ownership often comes with its own legal responsibilities, no matter how hands-off they try to be. Other times, the management company is the one calling all the shots, deciding maintenance schedules, hiring staff, and setting the budget. If they had control over the dangerous condition and ignored it, that control becomes a big spotlight pointed right at them. Here's where people get confused. They think only one party can be blamed, like it is a competition with one winner. In reality, injury law often allows multiple parties to share responsibility at the same time, almost like a group project where everyone still gets graded. Think about a contractor hired just to fix elevators. If that contractor did sloppy work and someone got hurt because of it, the contractor can be pulled into the case too, even if they never personally owned a single brick of that building. Inspection records matter just as much as ownership papers. If an inspector flagged a hazard 6 months ago and nobody fixed it, that paper trail becomes one of the most powerful pieces of evidence in the entire case. Communication records help too. Emails, texts, work orders, anything showing someone knew about a problem and sat on it. It is kind of like finding old text messages that prove someone definitely saw your message and just left you on read. A lot of people assume the landlord automatically pays for everything that happens on their property. That is a myth, because responsibility follows who controlled the hazard and who had the power to fix it, not just who owns the deed. This is exactly why injury lawyers dig through layers of contracts most regular people would never bother reading. They are basically corporate archaeologists, except instead of pottery shards, they are digging up liability clauses. Insurance complicates things even more because different parties often carry different policies covering different responsibilities. Your lawyer has to figure out which insurance company actually owes money, which can feel like untangling headphones that have been sitting in a drawer for 10 years. The takeaway here is simple. When a property has multiple layers of management, your case is rarely about pointing at one villain. It is about mapping out who controlled what, who knew what, and who ignored what. And a good lawyer treats that mapping like solving a puzzle instead of guessing in the dark. So next time you hear about someone getting hurt at a property with confusing ownership, you will understand why these cases take real investigation instead of quick assumptions. Want to learn more about how we help people untangle situations exactly like this? Check out our links in the description.